Good morning, angels, and thank you so much for participating in today's workshop and for all that you do for Northern Michigan and its companies and its ecosystem. We are truly blessed to have you in our region. Sorry that we cannot be there today. We pledged our podcast support to an inventor advocacy group who's having their first annual conference in DC, so that's where you'd find us today. But we are so glad that we could share this video with you. I know there will be lots of follow-up discussions today happening at the workshop, so if any questions do arise, please feel free to reach out to me. There will be contact information at the end of this video. So jumping right into it, oftentimes your first exposure to a company is through their pitch presentation, and I know you have a few this afternoon as well. And the three things that I like to think about, from an IP perspective when it comes to the pitch is around the coverage, the competitive landscape, and the portfolio as a communication tool. So from a coverage perspective, it should be really clear in the pitch the full portfolio view of what they are trying to cover. So this should be including patents, copyrights, trademarks, and trade secrets. Of course, you don't want them to tell you the trade secrets, but they should be able to say, we have a trade secret in manufacturing process. So really clear lines around what they protected, what they're trying to protect, and what's the different avenues that they're using to protect those innovations. From a competitive landscape perspective, most companies have a market competitive landscape slide. So this is how do they situate their product relative to other products in the market and how do they differentiate. This is super helpful, but of course can be skewed. You can highlight whatever aspects of a product that you want to kind of differentiate yourself. But what doesn't lie is the full corpus of information that is available to examiners, litigants, courts, to either grant a patent or defend it or invalidate it. So you really want to make sure that they've done some searching, and ideally through a real search firm that has, that does it as an art, because it truly is. And so ideally in this pitch, you will see some kind of IP competitive landscape that says, this is what we're trying to protect. And, we think that we have a good shot at protecting it because, we've looked at all of these different references and we think that we could get coverage for this key aspect. So thinking of those key aspects, the portfolio is also a communication tool. It really stresses a startup's core values and strategy, how they're really thinking about their business, how they're thinking about how the business has value, and how do they reflect that value in their patent portfolio. Not even the patent portfolio, their entire portfolio. Because sometimes, there is a lot of value in other aspects of their portfolio, and how is that being communicated through their portfolio. And so you should be able to talk with the company about it and understand how their values are being reflected in their patent portfolio. So that's the patent portfolio, their pitch as representative of the coverage of their portfolio, the competitive landscape, as well as the communication tool. So now moving on to the back-end diligence, if a few lucky companies find themselves in your purview now from a diligence perspective, there are a few things that I like to think about from a diligence side, and that is the quality of the portfolio, the enforceability, the ownership, and the economics of it. So thinking about the quality side of it, one of the easiest ways to have a problem in a portfolio is through breaks in chain of title. So that is how is the intellectual property conveyed from the inventor or the creator to the company. So this can be viewed in the USPTO's Patent Center, assuming that they registered it with the Patent Office, but also should be evident through their contracts. And so you want to make sure that there are no breaks in the chain of title. If there are, this is generally fixable, so it's maybe not a showstopper, but good to identify up front. The place where it can be a showstopper is if they broken chain of title, which then breaks their priority. And this can happen when you jump the pond, when you use the International Patent Cooperation Treaty to file internationally. If they didn't have appropriate chain of title, they may have broken it, and it's not fixable if they've already entered into these other countries, and they now have opened themselves up to more art because they no longer can get their earliest date of their portfolio. If you want more information on this is all what the CRISPR case was about and how priority chain was essentially broken and could not be rectified thereafter. So that's one key element of quality. Another is looking through the file history of the patent portfolio in the USPTO's Patent Center and verifying that they haven't said anything too limiting, too restrictive, too unfortunate during prosecution that would substantially limit the scope of their claims for later enforcement. And so really consider reading through the file history, things that they've said to the examiner, and if that's going to be a problem for how it can be interpreted or protect their product long term. So that's the quality piece. Moving to enforceability, um, you know, does their patent, this is getting maybe a little bit into the weeds, but does their patents, who's it trying to capture, right? Ideally, you don't want to be capturing the roofer who's using the hammer, but you want to capture the supplier or the manufacturer. And so just looking to see what does who does their portfolio aim to capture from an infringement perspective? Even if that's not necessarily their end goal for their portfolio, you want to make sure that it's quality at that step. And if you identify multiple parties that collectively would need to work together to infringe that claim, that is a red flag. Not to say, again, that that can't be fixed. Again, you could change the claims, amend the claims, go after continuation applications to fix the claims. But ideally, you only want one entity being targeted. So it's a supplier, a manufacturer. It's not a consumer, ideally. It's one software, it's one server or one, collection of servers. It's not multiple devices that need to work together. So really thinking through that, and it can be kind of tricky, but one asterisk on the user, from a medical device perspective, method of treatment claims can still be super powerful. Now, method of treatment, of course, targets a physician or doctor or somebody who's performing the procedure, but there's still immense value in the United States for method of treatment. So that's the one asterisk on that one. And then thinking about searching again, kind of returning to that topic because it is so critical. Thinking about searching from a patentability and freedom to operate perspective. So one, can you get the patent? And is it going to be strong enough in a court of law? So, how does the patent and its claims stack up to all that information? Have they done professional searching to make sure that they understand the competitive landscape well from an intellectual property perspective? But also, on the freedom to operate perspective, can they actually practice the technology? Meaning, are there any broad issued patents out there that could possibly prevent them from practicing the technology, at least, unless they got a license? And so, making sure that they have done some light freedom to operate searching. I don't recommend opinions. They are crazy expensive, but they should have some idea around what is out there and if there's anything problematic. So thinking about another aspect that's really right at the intersection of quality and enforceability is, have these companies sold, offered for sale, or otherwise publicly disclosed their technology before they sought patent protection? If they have, they may have irreparably destroyed their rights to get foreign protection on the invention. And so understanding to make sure that they were advised appropriately, that they knew about these things, whether they used their grace period or not, to accommodate for that disclosure activity is really critical to understand because, again, from a quality perspective, you want to make sure that they can protect all the things that they say they can protect. But from an enforceability perspective, you don't want somebody else finding out or bringing forth that they sold it previously or publicly disclosed it before filing a patent application that then knocks down the entire portfolio. So, understanding that, again, that timeline, so much of this comes down to timeline of chain of title, timeline of contracts, timeline of their public disclosure and sales activities, and are these all kind of in good shape to get you maximum ROI and de-risk the venture? So turning from quality to, I guess we already talked about enforceability as well, but into then ownership. Do they actually own the intellectual property? This sounds a little crazy, but a lot of companies confuse inventorship and ownership. They also confuse whether, that they've paid for services versus actually owning the output of those services. Just because you paid somebody for work, a contractor or third party, does not mean you own the output. Or you may own the output, but not the rights to the output. So just contract. They need to have contracts in place with any entity that they engage with before work begins. If you think about contractors, if they write the code, they own the code unless there are explicit contract provisions that convey those rights to the company. Third parties, you don't want that third party saying, well, we own it for whatever reason, and then having to go through some kind of arbitration to try to get those rights back. So again, do they have good contracts and clear intellectual property clauses in those contracts? Also thinking about government grants. these grants have explicit license provisions in the grant language for the government. Um, so many companies go after SBIR and STTR funding for developing their products, and this is fantastic funding. But if you've conceived of an invention or first actually reduced it to practice under the terms of the grant, the government has a paid up license. So if the government is going to be the company's main consumer, main customer, you've already given them a license. So understanding who the customers are going to be and where funding is coming from and grants is good to be aware of. Also, if they've done any work with contractors during the government grant term, any inventing the contractors have done is not owned by the company. Super crazy, aspect of government grants that's hard to control. You want to make sure that any contractors that are working for that company did not work on government grant projects, especially if they were innovating. If they were, maybe some obscure part of it that was not involved in innovating, it's fine. But any innovation needs to be done by employees that already have provisions in their contracts to assign the rights to the company. Contractors cannot assign their rights to the company. And so then lastly, what is the economics of their portfolio? What is their plan? Are they planning, to just use it for defensive purposes? Completely fine. Are they planning to license it or use it? Are they planning to sell aspects of it? Just again, they should be able to articulate what is the goal for their portfolio and how they're going to leverage it. Because ultimately, that's the true value in intellectual property is how you're going to leverage it, how you're going to use it in the market, how you're going to play with it in the market. And so, again, having funders that can articulate that. So I know I've given you a lot to think about. I've given you a lot to think about from the pitch side of it, and then from the diligence on the back end, thinking about, the economics, enforceability, the quality, and the ownership of it all. And so if you have any more questions, there is a link on the video to get more resources to go deeper on any of these complex topics. But I'm also happy to answer any questions. Please feel free to reach out to me. Otherwise, have a wonderful workshop and we'll talk soon.